If you've ever made a false claim to U.S. citizenship, you might be in big trouble. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, Washington, D.C., and Chicago, Illinois. On August 20th, 2025, USCIS issued a new policy memorandum, and it was to alert stakeholders that they are updating the policy manual as it relates to false claims to U.S. citizenship. You might be asking, what is a false claim to U.S. citizenship? Well, if someone is not a U.S. citizen and they tell people that they are, that would be a false claim to citizenship. Now, historically, it's been when people do that to gain some kind of a benefit. But under these new guidelines, USCIS is going to be a lot harsher and a lot stricter in interpreting when people break the law and falsely claim U.S. citizenship. This video is going to tell you everything you need to know and how it all fits together. Any immigrant in any status could make a false claim to citizenship. If you're not already a U.S. citizen and you tell a bank, a landlord, a school, an employer that you already are a U.S. citizen, that's what's going to get you in trouble. And the big thing you need to understand now is there used to be some wiggle room. There used to be some forgiveness. There used to be some grace. Not anymore, not in 2025. The biggest thing that you need to understand is that USCIS is shifting to a strict liability model. In other words, they don't care what your subjective intent was when you made your false claim to citizenship. In their mind, if you made a false claim to citizenship, it doesn't matter what your intent was. It doesn't matter if it was a mistake. It doesn't matter if it was unintentional. If you made a false claim to citizenship, in other words, if there's a statement of citizenship that turns out to be untrue, then you're going to be denied any immigration benefit in the future, and you are subject to deportation. And this is a big change because previously an officer could inquire into what happened. They could ask, did you do this on purpose? Why did you do this? What were the circumstances surrounding when you did it and why you did it? None of that matters anymore because now the only thing that matters is that you did it. And USCIS says that if you did it, the hammer will fall. So they don't care in most cases about your age or your mental capacity or your beliefs as to whether or not it was even true. The only thing that matters is, did you make the statement? If so, you are liable for that statement and you are subject to all the penalties that follow, including not being able to get another immigration benefit, not being able to adjust your status, not ever being able to become a U.S. citizen. Another big change in the August 20th update is now the burden of proof shifts to the immigrant. So if an immigrant has made a statement of citizenship and that statement is not true, it's their burden to show that one of the very limited exceptions apply. If they can't meet their burden, then they are going to be punished. They are not going to be able to get their immigration benefits and they're not going to be able to become a U.S. citizen. This is a big change. In the old days, USCIS carried the burden, but USCIS has now declared that after August 20th, 2025, to any cases that are in the pipeline, either already on file or that will be filed after that date, that those people are going to have to prove to the satisfaction of USCIS that they did not make a false claim to citizenship, that one of these exceptions does apply. It's going to be a very narrow path for a non-citizen to establish that they did not make a false claim to citizenship if there's any kind of question about such a claim. And this fits with the overall Trump approach to tightening the noose around the necks of immigrants, making it harder and harder to do things the right way, making it easier for USCIS officers to say, hey, you broke the rules, you're getting deported, you're not becoming a citizen, you're not getting an immigration benefit. That's the end goal. That's just one piece of this overarching approach that USCIS has, which is to slow down immigration and to punish immigrants that they think didn't do things correctly. In announcing the August 20th, 2025 change in the rules, USCIS relied heavily on a case called Matter of Zhang. That's a case from 2019 that was issued during the first Trump administration. It's a little bit of a strange case, but it illustrates in a big way what we're talking about. So in that case, Mr. Zhang had obtained a fake citizenship certificate from a former INS officer. Now that's a very strange set of circumstances. I've never heard of somebody getting a fake certificate of citizenship, but at the end of the day, he held himself out as a U.S. citizen when he was not, in fact, a U.S. citizen. In fact, he took that fake certificate of citizenship, applied for a passport, and used that passport, and USCIS was left to ask the question, does it matter what his intent was in making this false claim to citizenship, in obtaining this fake citizenship document, and using it to obtain a passport? The board held that the intent of Mr. Zhang was not important, that simply because he made the claim of citizenship, he was removable from the United States and he was ordered deported. I'm going to read you some of the opinion. The BIA held that intent is not required. According to the BIA's interpretation, the statutory text of INA 237A3D1 contains no intent element. Unlike other provisions of the INA, the Immigration Nationality Act, which explicitly require willful misrepresentation, because this section only requires proof that the person falsely represented themselves as a U.S. citizen, the government need not prove that they had the intent, that Mr. Zhang had the intent to deceive, or even whether he knew the claim was false. So what they're saying is, you make the claim, you get the pain. You say you're a U.S. citizen, you're not getting another immigration benefit. You make that false claim, you might get deported. That's where we're headed. That's what USCIS is doing, and that's what this August 20th, 2025 policy memorandum is doing. Is it's taking the Zhang case from the Board of Immigration Appeals and they're weaving it into the policy manual. They are making it much, much harder for an immigrant to argue that their claim of citizenship was unintentional or was ill-informed or was a mistake. Right now, USCIS is saying, we don't care. So in its update to the policy memorandum, USCIS is making clear that your purpose, the reason why you did it, maybe it was to get an apartment, maybe it was to get a job, maybe it was to get further along in line for something. It doesn't matter what your purpose was. It doesn't matter if you had a good purpose or a bad purpose. The fact of the matter is that USCIS is going to treat everybody the same. If they've made the claim, then their purpose is not important. And USCIS is going to simply look at the violation and not at the full context of why you did what you did. This is going to make it harder for immigrants to argue that they're still adjustable or still eligible for an immigration benefit or still eligible for citizenship. It's also going to make it harder for attorneys to be creative and make arguments that this person didn't intend it, so therefore it should be forgiven. There's no more forgiving false claims to U.S. citizenship, and that's what strict liability means. The prior version of the policy memorandum said it had to be done in order to obtain a benefit, but USCIS said no, it doesn't matter why you did it, the purpose isn't important. So let's talk about retraction. So retraction is what happens when somebody inadvertently, mistakenly makes a claim to citizenship and then they try to retract. USCIS is again tightening the rules surrounding that. Let me give you some examples of when retraction usually comes into play. So I've heard from many immigrants over the years who went to get a new driver's license. And when they got their driver's license, somebody at the DMV assumed that they were a U.S. citizen, marked that box, and processed them as a U.S. citizen. Well, later on, they got a voter registration card and they realized that somebody had mistakenly concluded that they were in fact a U.S. citizen, or maybe even they themselves checked a box and said that they were a U.S. citizen as a mistake in applying for a job. Then the issue comes up, well, did they retract that? Did they correct it? Did they notify the person that they had told that they were not a U.S. citizen and do everything they can possible to correct it and retract it? So retract means to pull back. And so did they do that? Well, historically, a timely retraction was a great way to get around a false claim to U.S. citizenship. No longer. USCIS is saying that we're going to tighten up those rules on retraction, and here they are. Was it immediate and voluntary? Now, many times people will mistakenly make a false claim to citizenship, especially in that voter context or employment context, and they don't find out about it for years. They don't find out about it till they get a jury summons or their voter registration card or some piece of literature in the mail about voting, and they realize, oh my, somebody thinks that I'm a citizen. I know I'm not a citizen. I never told anyone I was a citizen, but somehow, some way, this has now been established and you need to timely retract it. Well, under the new rule, it has to be immediate. You have to do it right away. And that's going to make it harder for non-citizens who have inadvertently made a claim of citizenship to walk that back, to retract that, because it wasn't done immediately. And if it wasn't done immediately, then USCIS is going to stick you with it. The retraction must be clear and unequivocal. What that means is you can't sort of waffle. You have to make it yourself. You can't do it under questioning. So sometimes the issue of a false claim to citizenship will come up for the very first time at a USCIS interview, or if a government official inquires after you've made that claim to citizenship that's incorrect, they look at it very strictly, and unless you made it crystal clear immediately after you did it and that you didn't do it after government prompting, in other words, the USCIS officer or some other state or local government official asked you, hey, are you sure you're a U.S. citizen? If you weren't entirely sure when you tried to retract the false claim to citizenship, they're going to hold that against you. And finally, the third piece of a successful retraction is, did you do it before the government took action based on your promise. So if you got a job, if you got a driver's license, if you got some kind of state benefits, or if you got a voter registration card, or if you voted, if the government took action based on your promise that you were a U.S. citizen, that's going to cut against any argument that you have that retraction should apply here and that you shouldn't be held for the erroneous claim to citizenship. They're saying you're not going to be allowed to retract it because you didn't do it right away, you didn't do it unequivocally, and you didn't do it before we asked you about it. So for those reasons, we're going to hang that on you. Officers are being instructed to treat almost every claim to citizenship as a false one, and that retraction in most cases will not serve as a defense to the false claim. Now I need to talk about intent. Did you have the subjective intent of misleading a U.S. government official when you made your false claim to citizenship? Did you have good intentions? Did you have bad intentions? Now, before we talked about purpose. Purpose is what was the reason that you did it or what happened when you did it. But intent goes to your heart, to what's in your mind. What are you thinking? What is your plan? Do you have an evil plan or a good plan when you made the false claim to citizenship? And what USCIS is saying with this new rule change, intent doesn't matter. The officer can't take into effect that maybe you were a young person, or maybe you don't have the best mental capacity, or maybe you had a pretty good reason to believe that you already were a U.S. citizen. Those things don't matter anymore. Moving forward, if you make the false statement that you're a citizen, your intent is irrelevant. The officer is directed to disregard it, and they can't use that good intent for a reason to look past the false claim to citizenship. USCIS has even updated its policy manual to talk about the 5 steps that an officer should take in order to determine whether a false claim to citizenship renders somebody inadmissible to the United States. That is, not eligible for any more immigration benefits, not eligible for a green card, not eligible for citizenship. The first step is determine whether the alien made a false claim of citizenship. So was there a false statement that the immigrant was a U.S. citizen? Next, determine whether the alien made a false claim to citizenship on or after September 30th, 1996. Now, that's an interesting date, and that comes from 2 immigration laws that President Clinton, a Democrat, signed into law in the mid-90s. The law changed on September 30th, 1996, so the officers need to look at that and to determine when the false claim occurred. Next, determine whether the alien's false claim to U.S. citizenship was for any purpose or benefit under the Immigration and Nationality Act or under any other federal or state law. Now, I think this is a game changer. Now you're talking about a much more expansive list of reasons or ways in which somebody made a false claim to citizenship, including under state law. So I think you're going to have to think long and hard about whether or not getting a driver's license and somehow indicating that you're a U.S. citizen might be a problem. Getting any kind of state benefits might be a problem. I think that step 3 is a real game changer, and it might keep a lot of people from applying for their next immigration benefit. Step 4, determine whether the alien timely retracted the false claim to U.S. citizenship. Now, we talked about that, about what a timely retraction is. How fast does it have to be? How certain does it have to be? And whether or not USCIS is going to give it credence. And then the last step is determine whether the alien is not inadmissible because a statutory exception or waiver applies. So that's what we're going to talk about next. Exceptions or exemptions for false claims to citizenship. In the August 20th, 2025 update to the policy manual, USCIS makes it clear that they're going to be very strict in who they give exceptions to or exemptions to, and we're going to talk about them now. So there are only 2 types of groups that are named specifically in the Immigration and Nationality Act as being eligible for exceptions to the requirement that you not make a false claim to citizenship: special immigrant juveniles and registry applicants. That's very, very few numbers of people, but that's all the statute provides for, and that's all USCIS is going to recognize. So gone are the days where they might look for other kinds of exceptions, like for people of low mental capacity or of a young age, or who have a good faith reason to think that they were a citizen. Those days are over. And the statutory exception is also going to be looked at very narrowly. Let me point it out to you. So it's been rewritten in a much more restrictive way. The core elements, both parents being a U.S. citizen and the residence for the child started before they were 16, and that they had a reasonable belief of citizenship. But the new text explicitly states there are no exceptions based solely on age or mental capacity. In the old version, officers may have been more open to arguments about minors, honest mistakes, or incapacity. USCIS says that's all over. They say Zhang overruled any other policy memos. All prior rules from USCIS that allowed for discretion are now disregarded, and Zhang is the law, and the narrow exceptions and exemptions for false claims to citizenship will be enforced. USCIS also added a waiver section, and they recognize that there are waivers for people who are seeking asylum, those trafficking victims, those looking for legalization, or those who came as refugees, but it's under a heading called Congress authorized waivers. That phrasing makes clear that USCIS sees itself as having no discretion beyond what Congress explicitly provided. So even the possibility of good moral character arguments in registry cases is downplayed in favor of a stricter reading. So in the last part of these changes, they made it so that the rule applies to all immigration benefits, and they narrowed when exceptions might apply. So it just got a whole lot harder to get around any kind of statement that you were a U.S. citizen. So if you find yourself thinking about applying for another immigration benefit and you know that you've made a false claim to citizenship, one that USCIS might already know about because you might have disclosed it in a prior visa application or adjustment application or change of status application or naturalization application, that false claim to citizenship is going to be a whole lot harsher on you. It's going to cause you much more difficulty because you're not going to get an immigration benefit. You're not going to be able to become a green card holder or a citizen when you disclose that to USCIS. It's strict liability now, which means you did it. USCIS is going to use it to prevent you from getting benefits, to prevent you from getting your citizenship, and from any other immigration benefits. So you might want to think about not filing for your next immigration benefit. You might want to think about using an attorney to help you. You also might wonder whether or not this is even legal, and time will tell whether the courts uphold the strict interpretation of the false claim to citizenship rule. We're going to have to look at the regulations, look at the statutes, see if they are going beyond their authority, which they seem to be trying to do. So this subject may be litigated, so stay tuned. But in the meantime, if you're thinking about applying for an immigration benefit and you want to work with us, whether you've made a false claim to citizenship or not, you can give us a call at 314-961-8200. Email us info@hackingimmigrationlaw.com. If you're just looking for free resources, we have a ton of those. We have our Immigrant Home Facebook group where we have thousands of immigrants talking about the immigration process every day. We have our YouTube channel that you can subscribe to and turn on alerts so that whenever we post a new video like this one, you'll be alerted. You can also join us on our Immigration Answer Show. That's me answering questions from immigrants for free 3 or 4 times a week. We love doing that. If you want to get in the waiting room to ask me a question, just text the word show to 314-470-3300. Thanks a lot, and we'll see you next time.